Purple Tree Crew, connecting people, building communities, helping clients to build multi-generational wealth through real estate.
Today, we have the privilege of having Bobby Vakili with us again. Bobby is the founder of Vakili Law Group, a boutique law firm located in Thornhill, serving the greater Toronto area. They are focused on real estate law, private mortgages, business law, and wills and estates. Vakili Law Group has expanded their business over the last 13 years and have closed thousands of transactions in the past 13 years, helping our mutual clients. Bobby Vakili, welcome.
Yes, thank you, Mitra. Thank you for that warm welcome. It's great to be here again. I look forward to this conversation and happy to be here.
Thank you. So, Bobby, we had a podcast series last time about a couple of months ago. We covered a lot of legal matters that was very important for our mutual clients. Today, focus is going to be on landlord and tenants. And this is a very hot topic that we are literally experiencing nowadays. And we start with the questions of conditions and restrictions a landlord can impose in a lease agreement. Can you tell us more about that?
Yes, that's a great question. You know, I'm dealing with a lot of issues in my practices as well, revolving around landlord and tenant issues. I think a lot of this is a result of what's transpired since COVID. There's a lot of delays in the landlord and tenant board tribunal, and those delays are creating a lot of frustration for both sides, both the landlords and the tenants. In terms of the restrictions that a landlord may impose, something that comes up frequently in my practice is landlords want to know, you know, by what amount they can increase their rent year over year. Ontario is a rent control province, and there are certain restrictions that are in place. For example, in 2023, the guideline issued by the government is a 2.5% increase from the previous year. So that means a landlord cannot increase the rent of a tenant by more than 2.5% without obtaining the tribunal's consent. Now, this rule does not apply to all properties. For example, new buildings and nearly all new basement apartments created after November 15th of 2018 are not subject to rent control. So in other words, if a new condo was built after November 15th, 2018, the landlord would not be restricted in how much they can increase the rent.
That's great. Bobby, what if is an existing condo or property, freehold property, that are built before 2018, but there is a huge difference between the current market rent and the actual rent that the tenant is paying? Is there any way, let's say if the rent is 30, 40, 50% lower, can landlord request an increase that would be above that 2.5% rate increase?
There is. You would have to make an application to the landlord and tenant tribunal, and you would need to get their approval. I don't see a lot of this in my practice, and I'm not sure how sort of lenient the landlord-tenant tribunal would be in helping a landlord in this type of situation. In my experience, you know, the Residential Tenancies Act is really primarily designed to protect tenants. So the laws are generally favor the tenant in Residential Tenancy Act, but in commercial leases, you know, it's opposite. The laws are really more sort of landlord friendly.
Okay. So, Bobby, I have a question, actually a situation that is happening right now for one of our clients who actually requested the tenant to move out because simply he lost the job and the mortgage payment on his current property has increased since last year, and he definitely needs to downsize and put his property, his current residence, on the market. The tenant is not moving out, and even if it's been clearly indicated that his intention is to move to the property that is rented because of his financial struggles. The tenant is not moving out in the last 10 months, and he has a tribunal date for hearing. And why in a situation like that, the tenant would not move out?
Well, if the proper notice has been provided, and in this instance, it seems like it would have been the N12 notice for personal use, the tenant does have an obligation to move out, but, tenants are taking advantage of the backlog in the tribunal, and they are well aware of what's going on. And, they are informed that it can take up to 12 months to get a hearing date. So, they're just taking advantage of the situation, in my experience.
Okay. And on a hearing, that shouldn't be any problem for landlord if, let's say, he has all the proof of his current situation to just request that tenant moves out, and then he would move in to his rental property. Is that correct?
Correct. As long as all the notices were completed correctly and the 1 month compensation is paid prior to the date indicated in the notice, then the tribunal, ought to grant the request and would terminate the lease. The only instance where that would not apply is if a landlord made an application in bad faith. So if a landlord makes an application in bad faith, in that instance, the tribunal would not assist the landlord in terminating the lease.
Of course. Thank you, Bobby. So we also hear a lot of tenants have pets, dogs, cats, and if the condo board, for example, permits the pet, and there is no restriction on that, either on the numbers or the size, can landlord impose no pets in the unit or in the house?
Right. No. Under the Residential Tenancies Act, restricting a tenant from owning a pet or having a pet on the premises is not permitted. So that would not be upheld if such a provision was included in a lease. Now, the only thing to consider here is if it's a condominium and the condominium's bylaws or rules have pet restrictions, then in that instance, those restrictions could be upheld.
Okay. But if, let's say, the condo board allows the pets and the landlord even has a clause, no pets, and after a year, the tenant brings a pet, landlord has no recourse of saying that, I don't want pets in my unit.
No, unfortunately, the landlord cannot restrict the tenant from, owning pets or having pets in the unit.
Okay. Regarding the lawn care or snow removal, we have had clients who actually sign an agreement confirming that they would take care of the lawn or snow removal, but then they didn't. What's the recourse for landlord when it becomes maintaining and the freehold property?
Yeah, I see this question quite often as well in my practice. And, and many lease agreements that I have reviewed do include such provisions whereby the tenant is required to cut the grass or complete snow removal. That term is not enforceable. So if you try to evict a tenant because they're failing to uphold that particular term in a lease, you won't be successful, and you're actually required to have a separate agreement with the tenant that basically where you have to agree to compensate the tenant to provide those services. Mm-hmm. So you can't simply demand for the tenant to provide these services in lieu of, let's say, reducing the rent or even as part of the rent, it's not permitted. The tenant there needs to be a separate agreement, and the tenant has to be compensated separately.
So what I'm hearing, you cannot add on the lawn care or snow removal as part of the agreement. It must be another agreement where the landlord is compensating the tenant for servicing this kind of job or maintenance, and that would not be incorporated into the lease agreement or pricing negotiation. Is that correct?
Exactly, that's correct.
Okay, perfect.
Purple Tree Group, connecting people, building communities, helping clients to build multi-generational wealth through real estate.